Good evening, this is Venecia Wong from Taylor's News. Over the recent years, cases of rape in Malaysia have been increasing at an alarming rate. Currently, there are 3,000 rape cases reported annually where only 2 out of every 10 cases are reported. The recent news on rape jokes where a Malaysian high school girl talked about her male teacher's rape jokes at school has triggered a nationwide conversation over sexual assault. This has raised concern within the society and thousands of Malaysian users have joined the online movement dubbed as #StandWithIron. One fact that should be understood clearly is that the act of rape was never the fault of the victims. However, in Malaysia, awareness seems to be lacking in this aspect. Legal practitioners and activists have voiced disappointments over the regressive stance taken by the government in refusing to immediately address this matter of law appropriately. I will now pass you over to our roving reporter, Ms. Liew Lok Yee.
I'm here at LIC and Carl Law Firm to speak to one of the legal experts in the area of criminal law. With us today is Ms. Ying Chia to share her knowledge on this issue. Ms. Ying Chia, can you give us a brief context on what the law of rape in Malaysia is like?
Yeah, sure. So the definition of rape under Malaysian law is found under Section 375 of the Penal Code. Essentially, under this section, rape can only be committed by a man as the offender upon a woman as the victim without her consent, and it is necessary to show penetration by penis and act constituting to sexual intercourse. This is the definition from the Nasrul Anwar bin Abdul Samad case. Sadly, the issue of rape has received much attention in Malaysia with regards to its inadequacy of legislative protection.
Thank you, Ms. Ying Chia and Ms. Liew Lok Yee. As in September 2020, women's rights groups have urged the government to revamp what they call outdated laws. Speaking to Taylor's News, the Women's Aid organization stated that there are still areas to improve, such as recognizing marital rape and the needs for reforms concerning the law of rape towards the Malaysian Penal Code. In the following presentations, the inadequacy of protections in relation to rape under Section 375 shall be discussed along with its possible legislative reforms.
Hi, I'm Lok Yee. The area in the law on rape that needs to be improved is that the offence of rape in Section 375 of the Penal Code should not be gender specific. Under Section 375, rape can only be committed by a man and the victim must be a woman. This definition is problematic as it does not protect a man from non-consensual sex. An argument for rape being a gendered crime is that women are much more likely to be raped than men, and it affects many more women directly. However, according to research studies, men can also be victims of non-consensual sex. The amount of harm it causes to men when they are forced to engage in sexual intercourse against his will or without his consent ought to be taken into account. Such harms can result in both adverse psychological and physical responses which are equivalent to those experienced by female victims. Hence, the offence of rape should be expanded as men can also be rape victims with either men or female perpetrators and thus should be equally protected under the law. Another issue arises when a person has undergone gender reassignment surgery. In Malaysia, a person who has undergone such surgery can only be regarded as belonging to the sex after the person has sought a declaration from the court under the Specific Relief Act 1950. Therefore, a male may have successfully gone through the gender reassignment surgery and have female genitals, but cannot legally be the victim of rape unless he has successfully applied to the court for a declaration. Meanwhile, the perpetrator could be a person who is born female, but subsequently went through gender reassignment surgery, having a penis, but no offence will be committed if the perpetrator is not declared as a male. Comparison should be made to the law in Thailand, whereby the offence of rape has been amended to use the term any person so that the perpetrator as well as the victim could be male or female. Similarly, in the United Kingdom, the law on rape was amended by the Sexual Offences Act 2003 that removes the mention of gender when defining the offence of rape under Section 1 of the Act. Hence, in the United Kingdom, there's no need to identify whether the victim is legally a female, as long as there was penetration of the victim's vagina, anus, or mouth with the perpetrator's penis. There is also no requirement to determine whether the perpetrator is a male, as long as he has a penis. In short, it is proposed that that the genders specified in Section 375 should be changed to any person to reflect that both the genders can be the perpetrator or the victim to close the loopholes of the law on rape.
Hi, I'm Ying Chia. The next area that needs to be improved is that the offence of rape should not be restricted solely to vaginal sexual intercourse. Rape, under Section 375 of the Penal Code, requires there to be vaginal intercourse, although this is not explicitly stated. This can be clearly inferred by reference to the Penal Code itself on two grounds. Firstly, the term sexual intercourse is used in Section 375. This is taken to mean penetration of the vagina with the penis, since the explanation to Section 375 provides that penetration suffices as sexual intercourse that is required for the offence of rape. This proposition is further substantiated by Malaysian case laws on rape, which have made clear reference to penal vaginal intercourse. For example, in the case of Nasrul Anwar bin Abdul Samad against public prosecutor, the charge of rape had failed as there was doubt as to whether the accused penetrated the victim's vagina with his penis. Secondly, rape under Section 375 does not refer to oral sex, anal sex, or penetration by foreign objects or other body parts. This is because they have already been specifically provided for under the Penal Code as separate offences in Section 377A, as carnal intercourse against the order of nature, and Section 377CA as sexual connection by object, etc. The reason of why the offence of rape was confined to penal vaginal sexual intercourse at the outset is obsolete. Its origins can be traced back to when the law of rape was particularly concerned with the protection of virginity. Hence, it is submitted that the scope of the law on rape in the modern world should be more concerned with protecting the modesty and dignity of a person, regardless of gender, and do away with the olden days conceptualization. The law should now move on and embrace other non-consensual sexual conducts of severely degrading nature to equally come under the offence of rape. Many countries, including India, in which the offence of rape is governed under the Indian Penal Code, which our Penal Code originates from, have gradually moved away from this position. Despite the fact that in India, the offence of rape is still only committed by a man, it has extended to cover anal sex and oral sex, including both fellatio and cunnilingus. It is also no longer confined to penile penetration. It is sufficient that the penetration is by object or body parts. It is suggested that, in this aspect, the definition of rape under Section 375 shall be thoroughly reformed to do away with the categories of separate offences, namely carnal intercourse and sexual connection by object, etc., following the position in India. It naturally follows that the provisions in relation to it will be removed as well. By widening the definition of rape, the law will reflect the severity of the offences, so that a particular crime would then not be viewed as less serious as compared with the other. This is in line with an informed understanding of the reliability of rape as a medium of humiliation and degradation of victims through sexual means. For the reform, reference can be made to the position of Thailand, our neighbouring country. In Thailand, the definition of rape under Section 276 of the Thai Criminal Code is wider in the sense that it includes all forms of vaginal, anal, and oral sexual intercourse, whether or not it is committed by using objects or body parts. Plus, it is also not gender-specific. In short, all non-consensual sexual intercourse should be regarded as equally serious, irrespective of its form. Thank you.
In Malaysia, it has been recognized that women are still not truly free and independent. Upon reading the exception to Section 375 of the Penal Code, it states that sexual intercourse by a man with his own wife by marriage is not rape. Hence, it is significant to note that marital rape is yet to be recognized in Malaysian law. What can be derived instead is that consent to marriage is also consent to sexual intercourse. Questions have been put forth as to why is there a need for laws criminalizing marital rape, as there is already Section 375A of the Penal Code introducing the crime of husband causing hurt in order to have sexual intercourse. Moreover, that the Penal Code further includes Section 376A, 352A and the Domestic Violence Act 1994, which provides for the protection afforded to married women against sexual acts. However, it is argued that this does not adequately address the offence of rape. It is observed that Section 375A creates a focus instead on the conduct of the offender by requiring different elements of intimidation as opposed to rape. To note, the punishment for the offence is 5 years imprisonment as compared to every other category of rape, which is up to 20 years. As such, it seemingly portrays a lesser severity of the action of rape and in effect neutralizes the deterrent effect of the law. It is suggested that the government should do away with Section 375A with its differing elements from that of rape, as it criminalizes hurt or fear of death or hurt to his wife, and not the act of non-consensual sexual intercourse. On the same note, it is unfair and unreasonable to maintain a law that gives a married man a legal license to violate a married woman's physical being without her consent. Marriage, according to the classical juristic definition, is a contract prescribed by legislation denoting lawful entitlement of each of the parties to enjoy the other in a lawful manner, and as such should not largely strip away the protections of the criminal law from a woman on occasions when she refuses ordinary marital sex. Marriage is not one that gives the husband permanent unqualified consent to a sexual relationship. In this matter, Section 375A does not include the issue of consent or non-consent from a wife. With reference to English law position in the case of R against R, it was held that there was no longer a rule of law that a wife was deemed to have consented irrevocably to sexual intercourse with the husband. Therefore, a husband could be convicted of rape or attempted rape of his wife where she had withdrawn consent to sexual intercourse. This present law of England and Wales that consent should be a clear factor in marital sexual relations is one amendment proposed that Malaysia should undertake. Accordingly, it is suggested that amendment should be made to the definition of rape to include a consent-based definition of sexual assault with no restrictions or limitations. Following as what the Convention on Elimination of All Forms of Discrimination Against Women had requested Malaysia in 2006, legislation should be enacted defining rape on the basis of lack of freely given consent to the wife to sexual intercourse. Furthermore, Malaysia being a Muslim-majority country, regards may also be directed towards the Sharia perspective on the criminalization of rape. It is held firmly under the Sharia law that sex with a spouse was a religious duty, it being the wife's duty to submit to the husband's sexual needs. Thus, marriage under the Sharia law seemingly is also a shield for perpetrators who can avoid the charge of rape, as a man would not be acquitted had a victim sought justice under the Sharia law. In view of this, it is clear that the current legislation is inconsistent and inadequate in protecting victims of sexual assault in marriage, and marriage remains a shield for perpetrators. Notably, Malaysia's neighbour Singapore, though carries a similar exception found in Section 375 subsection 4 of the Singapore Penal Code, has since progressed and set this area of law to be repealed as part of its changes to its penal code. It is submitted that Malaysia should follow in step to criminalise marital rape through reform or revision of the criminal law or penal code. There should be no violation of body integrity and sexual autonomy irrespective of the nature of the marital relationship between the perpetrator and the victim, and legislation covering rape must be amended so that appropriate charges may be brought against the perpetrator. Similarly, the harmonisation of Sharia law should be considered in parallel form.
Hi, I'm Lai Jing Yi. The age of consent is another area that should be improved, as the law on statutory rape in Malaysia leads to confusion. Under statutory rape, the law presumes that young girls are incapable of giving consent as they cannot comprehend the nature, quality, and the consequences of the act. However, the age of consent in this area is inconsistent. Under the Penal Code, different age of consent such as 12 years old and 16 years old are provided under Section 90 subsection C and Section 375 subsection G. Nevertheless, Section 2 subsection 1 of the Sexual Offences Against Children Act 2017 stated that the age of consent is 18 years old. This creates further confusion as a person under the age of 18 cannot give consent to sexual assault under Section 14 of the Sexual Offences Against Children Act. But a girl under the age of 18 and over the age of 16 can give valid consent for sexual intercourse under the Penal Code. Moreover, under Sharia law, the age of consent is decided on a case-to-case basis, depending on the judge's discretions, age of puberty, and more. Hence, the lack of standardizations of judicial reasoning puts the woman in a more vulnerable positions so that their state of residence determines their access to justice. Therefore, it can be deduced that the age of consent of the victim is inconsistent as to sexual offences. Hence, there is the need to re-examine the age of consent so that it is consistent throughout the law of statutory rape. In India, the age of consent had increased from the age of 16 to 18 under the Criminal Law Act 2013 and the Protections of Children from Sexual Offences Act 2012. This amendment is in line with the legal age for marriage of 18 years old. Since marriage with a girl below 18 years old is prohibited, sexual intercourse with a girl below 18 years old should also be prohibited. In this aspect, Malaysia should follow the Indian position in adopting a higher age threshold. Girls deserve the protections afforded until they reach the age of 18, in keeping with the international human rights standards. If the age were to be lowered, then it would open the floodgates of underage sex. Henceforth, it is necessary to relook into the age of consent of all legislations covering statutory rape by implementing the age of consent to 18 years old, to bring uniformity in the law and protect unwanted early pregnancy by the teenagers. Thank you.
Furthermore, question arises as to whether there is such a need to list down the circumstances making sexual intercourse rape under Section 375. It is proposed that the offence of rape under this section should be uncomplicated by removing subsections A and C to F, leaving only subsection B. Although Section 375 subsection A provides that rape can be committed if the sexual intercourse is done against the will of the woman, it is suggested that consent of a woman is a major factor for showing her willingness. In consent, the woman generally communicates her willingness for the particular act. Thus, if the sexual intercourse is not something that a woman is willing to engage in, the law should reflect reality and regard that she is not consenting to the same. Besides, it is proposed that Section 375, subsections C, D, and E are covered under Section 90 of the Penal Code, which provides for circumstances that do not amount to consent throughout the Penal Code. In short, there is no consent if the circumstances in subsections C, D, and E take place which are already covered under Section 90, and these situations will then fall back to subsection B, where there was no consent to the sexual intercourse. For subsection F, it seems to be the circumstances that is not covered under Section 90. Therefore, to simplify the law on rape, Section 90 should be amended to include the explanation of what can amount to a valid consent, as seen in Section 74 of the Sexual Offences Act, so that for subsections C to F, there is no consent as the agreement given was not by choice, and the woman did not have the freedom and capacity to make that choice. Thank you.
Next, there is also a need for the menstrual requisite for the offence of rape to be expressly provided for in the Penal Code. Section 375 in general does not make any reference to the required mental element of the perpetrator. In Malaysia, there are differences of opinion as to the nature of menstrual, which has to be proved by the prosecution. Contrastingly, in the United Kingdom, the Sexual Offences Act 2003 expressly provides that the accused must not have reasonable belief that the victim consented to the sexual act. On this aspect, the author Sankaran contends that the actor's risk of rape by the accused is already sufficient to prove intention. The menstrual element of rape as the perpetrator would have obviously had the intention to have non-consensual intercourse with the woman. Additionally, menstrual could also be presumed upon proof of each circumstance under the sections 375. It is also contended that in the absence of an express menstrual requisite, a man who honestly but mistakenly believed that a woman was consenting to sexual intercourse when in fact she was not, can still raise a defense of mistake of fact contained in Section 79 of the Penal Code to be acquitted of the charge of rape based on the case of public prosecutor against Teo Eng Chan. Section 79 states that nothing is an offence which by any person who by reasons of a mistake of fact in good faith believe himself to be justified by law in doing it. As a matter of course, it is argued that the menstrual requisite of rape still needs to be explicitly provided for in Section 375 itself, as Section 79 remains as a defence, and the burden of proving a defence lies with the accused instead of the prosecution. In other words, the accused would have to prove his innocence on the balance of probabilities that he made a mistake and that his mistake was made in good faith. Therefore, Section 375 should be amended to expressly provide for the mens rea requisite that the accused must not have reasonable belief in a consent following the UK Sexual Offences Act 2003. This is so that more clarity is provided under the law and that the burden of proving the mental state of the accused will shift to the prosecutions. Thank you.
In conclusion, the proposals for reform on the law of rape is as follows. Firstly, the offence of rape should not be gender-specific and should not be limited to penile vaginal sexual intercourse, as everyone deserves to be equally protected from all forms of unwanted humiliation and degradation through sexual means. Next, there is a need to remove the marital rape exemption on the grounds that married women should also be equally guarded under the law, taking into consideration of the absence of consent in sexual intercourse. Besides, the age of consent for statutory rape should be consolidated to 18 years old throughout the relevant areas of law to provide sufficient protection for young girls. Moreover, the structure and language used with respect to the consent in Section 375 and Section 90 should be reformed to provide a clearer framework to the law. The general section for consent in Section 90 should be amended to include a proper definition for what can amount to valid consent by mirroring the definition of consent in the UK Sexual Offences Act so that the circumstances in Section 375 can be removed. Last but not least, the menstrual requisite regarding the reasonable belief in consent by the accused should be expressly included in Section 375. That is all from our group. Thank you for watching.